Welcome to our October 29th webinar, Know Your Rights, Disability Protections under State and Federal Laws. And we are joined by Giulia Schaub and Nicholas Kennedy, who are both employment lawyers from Horne Daller. We really appreciate your time. And this is such an important topic and one that we haven't focused on very much. So thank you, Nicholas, and thank you, Giulia, and I'll let you both take it away.
Sure. Yeah, great to be here. And for those watching now, feel free to interact with questions if you have any. And for those watching later, feel free to reach out to us if you have any questions. I'm going to share my screen right now so I can show our PowerPoint real quick. Let me do that. Sorry about that. There we go. Okay. Let me share. There we go. Let me do this. Okay. All right. Can everyone see that okay?
Yes.
Great. Okay. Well, we know we were already properly introduced by Casey, so I appreciate that. But we work for the firm Horne Daller. We're located in Pittsburgh, and we specialize in employment law and securities law for plaintiffs almost entirely. So people that are working, we are their advocates. And we're going to be talking about, as Casey announced, workplace accommodations and related issues. So today we'll start with just kind of a brief overview of the three laws that will probably most affect your career as it relates to dealing with workplace issues and the interaction between your job and Parkinson's. So first we have the Americans with Disabilities Act. This is a federal law and it applies across the country and it prohibits employment discrimination based on disabilities. It covers employers with 15 or more employees. So if you work for an employer that has 15 or more employees, you will be covered by the ADA. It has a statute of limitations of 300 days from the adverse employment action. We're going to get into that in a little bit more detail, but basically, if you believe you've been fired because of your disability or denied a promotion or not being paid as much or something along those lines, you have 300 days to file a claim, and we'll tell you how to do that and get into the nuts and bolts of that. And the next point is on that issue. You would file a claim with the Equal Employment Opportunity Commission or the EEOC, and all of that can be done online. The next law is the Pennsylvania Human Relations Act. This law is specific to Pennsylvania, as the name denotes. And this prohibits employment discrimination on a number of categories, including disabilities. And this is an important law because it covers smaller employers. So this covers employers with 4 or more employees. So those of you who work for smaller employees may still have protections against disability discrimination as long as they have 4 or more employees. This has a shorter statute of limitations to file a claim. That's 180 days from the adverse employment action. And you file this with the state agency called the Pennsylvania Human Relations Commission. And the third law is called the Family and Medical Leave Act. This is a federal law. So like the Americans with Disabilities Act, it covers anyone in the country. And it prohibits discrimination based on FMLA leave. So if you need to take leave for your job, which we'll get into more details about that later, you are protected against being discriminated against. This covers employers with 50 or more employees. So it covers larger employers. And there's an asterisk next to it because there's some kind of nuances with that definition. But basically, you need to work for a larger employer to be covered by this. The statute of limitations is longer. So if you believe you've been discriminated against, you have 2 years from the adverse employment action. And this would be filed directly in federal courts if you're going to bring a lawsuit. So Americans with Disabilities Act, what you need to know.
Tell you what you need to know. The ADA protects individuals with disabilities, and these would be people with a physical or mental impairment that substantially limits one or more major life activities. That includes breathing, walking, talking, hearing, everyday functions. But it also covers individuals with a record of an impairment, even if they don't currently have a disability, such as any sort of history or previously being classified as being disabled, and individuals who don't have a disability but are regarded as having a disability. This means if the person has been subjected to discrimination that would violate the ADA because of an actual or perceived physical or mental impairment. The ADA also makes it unlawful to discriminate against a person based on that person's association with a person with a disability, so a family member, spouse, along those lines. Let's talk about Title I. Okay, so Title I prohibits employers from discriminating against qualified individuals in various stages of employment, beginning from the application process, firing, hiring, advancement, compensation, job training, and other terms and conditions and privileges of employment. It requires employers to make reasonable accommodations for qualified individuals with disabilities so that they can perform the essential functions of their jobs. And we'll talk about reasonable accommodations a little bit here, but that's basically any change or adjustment to a job or work environment that would permit the individual to perform the essential functions of that job, and also take into account any sort of accommodation they might need to do that comfortably. So whenever you need to, when a disabled individual needs to make a request for an accommodation, they start what is called the interactive process. As I said, this is on the employee to request this accommodation, so they have a duty to start the process. And once they have made this request, the employer must in good faith engaged in this interactive process. And that involves communicating with the individual or maybe their healthcare provider about identifying what an appropriate accommodation might be. This puts obligations on both the employee and the employer. And it doesn't mean that the employer must provide the requested accommodation. There can be a little bit of conversation about what would be best for both employee and employer in that situation. What you need to know about medical documentation: it is not always required. An employer can't ask for medical documentation when the disability and the need for a reasonable accommodation is obvious, or the individual has already provided sufficient information to substantiate a disability and that he or she needs that accommodation. There's no set time frame in which the employees must provide that documentation, and the documentation must be kept confidential in a separate file. So once again, I said we would talk about what a reasonable accommodation is. An employer does have a requirement to make that a reasonable accommodation to the known limitations of the employee making the request or the applicant making the request, provided that the accommodation does not pose an undue hardship or direct threat to the employer. An undue hardship is a significant difficulty or expense under whatever the circumstances may be. Examples of this might be increased costs, impact on other employees, or just a general disruption in business operations. And a direct threat is a significant risk of substantial harm that cannot be eliminated or reduced through a reasonable accommodation. An example of this might be if a given job involves working at heights and a person or an employee's disability affects their balance. This is an obvious threat to their safety, safety of other employees, etc. Reasonable accommodations allow employees to perform the essential functions of their job and still enjoy equal benefits and privileges of employment, but be mindful of whatever accommodations they need to do that. Okay, what you need to know about leave as a reasonable accommodation. Unpaid leave can be a reasonable accommodation provided it does not impose a hardship on the employer. Too far. But employers do not need to provide leave as an accommodation when it is not likely to enable the employee to return to work. The Third Circuit has told us that leave must allow the employee to perform the essential job functions in the near future. So there needs to be some sort of understanding of when the employee is expected to return to work. And employers do not need to accommodate indefinite duration of leave. And what you need to know about light duty. The ADA does not require employees to create light duty positions, employers to create a light duty position. But if they have them for, say, workers' comp purposes, they may have to offer those positions to employees with disabilities coming back to work. And FMLA qualifying employees need not accept light duty positions. They can just simply take their FMLA leave.
So I'm just going to stop screen sharing for a second and just see if anyone has any questions. I know we had some new people join us. And just want to ask if anyone has any questions about the Americans with Disabilities Act. This is going to be the primary law that is going to govern really most situations covering your membership. And this is really kind of the most litigated employment disability law out there. And it provides the most robust rights for anyone, including, like we talked about, accommodations. And workplace accommodations can really be anything. It's very situational specific. So it just depends on the individual's condition and the type of job they work. And it should be a very, in theory, it should be a very open and frank conversation with your employer. Just talking about specifically exactly what you need and why you need it and how it relates to your job. But oftentimes employers don't really understand their legal obligations, and that process breaks down, and that's kind of where we have to get involved to kind of put it back on track and help the employee keep their job when employers just don't really understand or care about the process. So that's kind of, sometimes you need intervention at that point to get it back on track.
Just a comment. The reason I attended this seminar was because I have a cousin, and the cousin became blind in his 20s, and he lives in Argentina, in Buenos Aires. So I understand that that would be a different set of legislation. But when he goes with a guide dog that he obtained in this country to restaurants and museums and places like those, people get very nervous and they don't want to let the guide dog go in because they say that the dog can be dangerous or uncontrollable. And my cousin has all kinds of problems with this type of situation. And I understand that the situation is different here, but I was wondering, with family law, family leave, is there a limit? Say that a caregiver needs to take time off to help an employee, to help a person with Parkinson disabilities to go to the doctor or to go to a neurologist or something like that. Can he ask for time off, or that would not be allowed or would be regarded badly upon?
That's a good question. Yeah, you can ask. So family FMLA leave doesn't just apply to the person with the medical condition. It applies to their caregivers, assuming they're close relatives. So if you're caring for a loved one and they need help getting to a doctor's appointment, you yourself can take family medical leave to take them to that doctor's appointment and to care for them. So it's Family and Medical Leave Act, and it applies to caregivers as well.
Do you know how many days of leave can a person take in a given time period?
You get 12 weeks of leave in a year. It's unpaid leave from your job, but it's 12 weeks of protected leave. It doesn't have to be all used at once. It can be used intermittently. So if you need a day here or there, you can use it in that scenario. And just to kind of come back to
Thank you.
your original point about service animals, you know, you'll see there's been a lot of controversies on airplanes with the difference between service animals and emotional support animals. And those are two very different things. So emotional support animals are not protected in the same way that service animals are under the law. So certain establishments can prohibit you from bringing your emotional support animal in. So if you have a dog or cat or whatever it may be, that's classified as an emotional support animal, you can be prohibited from bringing that animal into that establishment. They're just not given the same protections. But if you have a service animal that's legally designated as a service animal, there's a specific definition under the law, then you cannot be prohibited from bringing that service animal into places such as restaurants and public establishments. And a service animal is an animal, the exact definition escapes me right now, but it's an animal that is trained to perform a service. And that's kind of, I know it sounds simple, but that's kind of the definition. So I don't know if, you know, your membership ever deals with that issue, but it's two very different things. And so those types of protections are afforded to service animals and not emotional support animals.
Thank you.
Mm-hmm.
No, I think my cousin has problems, for instance, when he goes to restaurants, museums, or taxi cabs. Taxi cabs don't want the dog, and he needs the dog because he cannot see without it. He cannot see, period. You know, he has a total disability. So that's why I asked, but I think your explanation is very clear. Thank you very much.
Okay, yeah, absolutely. Okay, and so we'll jump into some question and answers just to give you some examples of, and I'll share my screen again here, kind of what types of scenarios and how this law will apply. So let me jump to this. Okay, so, and I'll ask Giulia to answer these questions, and she can kind of give some background in terms of what the law says. So, Giulia, can employers ask a job applicant whether she has Parkinson's disease?
No, they may not. This is a private matter. If they observe what they perceive to be symptoms of Parkinson's, they are not specifically allowed to ask, do you have Parkinson's disease? That oversteps what they're allowed to ask.
And that's a good point. And employees should not feel obligated to disclose that voluntarily. So you have no obligation to disclose that to your employer when you're applying for the job. Now,
Right.
Giulia, can employers ask a job applicant whether she can operate heavy machinery or drive a car?
Yes, especially if this pertains to the applicant's potential job duties if they were offered the job and take the job. This could affect business operations, their own safety of other employees. It's relevant to the job. So that's important for the employer to know that if the job applicant can do those things.
And that's important to note that distinction. So the first question would be just flat out asking whether the individual has a disability.
Mm-hmm.
But the second question is, if they ask, can you perform certain job functions? That's a more neutral, not targeted question, and that is a legitimate question that an employer can ask. And then, I guess we kind of touched on this. Is an applicant obligated to voluntarily disclose that she has Parkinson's disease?
No, they are not, as their private medical information.
Okay.
I appreciate you going over those questions, especially the last one, because I've heard from numerous people that have Parkinson's that are working, and, you know, I don't know if I should tell my employer. And, you know, you've explained that you certainly don't have to. And also, I think, you know, you've been talking about some of the protections if you do disclose that you have Parkinson's or another disability.
Yeah, the only time you need to disclose it is if you are asking for an accommodation. So if you want to trigger the accommodation process, as Giulia explained, it's the employee's obligation to open the dialogue, the accommodation dialogue. And so the employee has to give the employer enough information to start that conversation. So that at that point, it could be disclosing your diagnosis. But it only has to be disclosed to the people that need to know, which is typically an HR professional, maybe your supervisor. but nothing beyond that.
Thank you.
All right, next question and answer slide.
And did you change it? Sorry, Nick. I'm gonna ask you some questions.
Okay.
Can employers ask about Parkinson's symptoms observed at work?
Possibly. So it is very situational dependent. It depends on the nature of your job. So if you are exhibiting symptoms, whatever they may be, at work, and there's no correlation or threat to the kind of your safety or your ability to perform your job, then they should not be asking about symptoms observed at work. If you're operating heavy machinery and they exhibit maybe some type of physical movement that indicates that you might not be equipped to handle that type of machinery, then that's a different story. And they could ask for it because it may directly impact your ability to do the job. So it's situational specific. And it really just depends on the nature of your work and what the employer has observed in that situation.
Can employers ask for medical documentation before allowing an employee on leave to come back to work?
Yes. So typically, I mean, again, it depends on the type of leave, but if you're going on an extended leave, due to a hospitalization or a medical treatment or something like that, and you need to return, typically the employer can ask for a medical clearance to return to work, and that's legitimate as long as it is kept to the people that need to know.
Can employers tell an employee's coworkers that he or she has Parkinson's disease?
No. It is, and this is a common question I think that Giulia and I often hear, is it's not a HIPAA violation. If an employer were to, let's say you tell your supervisor and HR that you need an accommodation because you've been diagnosed with Parkinson's, it would not be a HIPAA violation if the employer shares that with your coworkers. But it would be, because they're not unless you work for a hospital or something like that, they're not an entity covered by HIPAA, but it would be a violation of the Americans with Disabilities Act because the employer has to keep that information in-house to the people that need to know. And if your coworkers, typically a coworker doesn't have a need to know that. And we come across these situations where, someone discloses their disability and then the next day all their coworkers are asking about that. And that's not legal. And that shows potentially what could be a precursor to disability discrimination if the boss is spreading information.
I have a follow-up question.
Sure.
And Giulia. So if you're letting the HR department know of your disability, such as Parkinson's, then is that representative allowed to tell your supervisor? I was curious how that might work.
Typically, it depends on the job. A lot of times the answer would be yes. If you're asking for specific accommodations, the supervisor might need to be part of that conversation if you need certain workplace modifications, but not necessarily. I think most situations I see the supervisor involved in those conversations just because of the nature of what you're asking for. But I wouldn't say it's a across the board rule in every situation. I know that's kind of murky, but that's the way the law in this area goes sometimes.
Naturally, as you can see, I am retired now, and I had Parkinson's probably when I was still employed, but I didn't know I had Parkinson's. So it was diagnosed after I was retired. However, I do have 3 children in employable age, and that I know of, they are very healthy. However, I always advise them not to hostilize the employer, because I think that it's a kiss of death to hostilize the employer in terms of promotion, raises, evaluations. After over 30 years of working, I concluded that there is no way to keep happy some bosses. Maybe I am too reactive, but that was with some bosses. But anyway, I was wondering if you could comment on whether telling an employee I have Parkinson's could result on silent reprisals of some kind or another.
Yeah, unfortunately, that's the nature of the world. Sometimes we run into disability discrimination cases where once the employer finds out, they start to retaliate. And one thing we don't have covered in our presentation that I could just touch upon briefly is there's another form of retaliation that's prohibited by ERISA. ERISA is a federal ERISA. Don't ask me to spell out the acronym. I at this point. But anyways, ERISA covers pension programs, it covers health insurance benefits and things like that. And I don't see these cases a lot, but sometimes employers will look at the situation and start to get worried about how much you will cost their health insurance plan. And they'll retaliate in that way too. So some employers are motivated purely just out of discriminatory bias towards someone with a disability, but sometimes they're also motivated out of concern that you're going to be a drain on their health insurance plan. And they might fire you and make up some nonsense reason for firing you to save a cost on what they view would be a big hit to their premiums, health insurance premiums. And that's prohibited under ERISA. It's a different law. It's not one you see often, but I have had examples of that, and I have litigated cases on that. I had one situation where an individual disclosed that their loved one had cancer, and they suddenly got put on a performance improvement plan and had their salary cut shortly thereafter. And their loved one was on the insurance plan of the company. So you'll see situations that can arise. So you have to be careful. And that's why if after you disclose your diagnosis of Parkinson's, suddenly you go from being the star employee to the worst employee ever, then that's a clear sign that there might be some discrimination going on and you need someone to intervene. But good question. Very good question.
Thank you.
We'll jump to Giulia to talk about reasonable accommodations.
Yeah, these are just some examples of what we thought would be reasonable accommodations for an employee with Parkinson's. There would be breaks to take medication, medical leave, as we just discussed, adjustments to work schedule. So that might be starting work earlier or later, depending on what that person needs. Permission to bring a service animal to work, permission to work from home. Specialized equipment, we were thinking maybe like a dictation advice, adaptive computer equipment, things along those lines. And again, just flexible work hours could be a reasonable accommodation as well.
And we'll talk now about, can employers refuse to hire individuals with Parkinson's disease because of safety concerns? And that depends. It can't just be based off of generalized concerns or, their uneducated opinion that someone with Parkinson's poses a threat. It has to be, they have to show a significant risk of substantial harm to individuals or others that cannot be eliminated through an accommodation, and they need to have objective factual evidence. So if your boss just believes that suddenly, that someone with Parkinson's, or the owner of the business believes that someone with Parkinson's poses a threat, but just pulls that out of thin air, that's not enough for the employer to refuse to hire you. They actually have to have typically a medical opinion or some type of expert opinion that you can't perform that job. And so sometimes there are things called functional capacity exams where you go to a physical therapist, and that physical therapist runs you through a battery of tests based on the physical limitations of the job. And that could be something that you would be required to undergo and could inform on whether you can perform the duties or not. So next we'll talk about the Family and Medical Leave Act. We touched upon this earlier, but we'll get into a little bit more details about this. Again, this is a federal law. And we'll talk about who is eligible for this law. So there's 3 requirements to be eligible. There's a service requirement, there's an hours requirement, and there's a worksite requirement. And we'll talk about each one in turn. So the first is the service requirement. So if you have to have worked for the employer for at least 12 months. So in your first year of employment with your job, you're not going to be eligible for FMLA leave. You might be eligible for, or that requirement, I don't want you to confuse this with the Americans with Disabilities Act. So as soon as you started a job, or even as a job applicant, you are covered by the Americans with Disabilities Act and protected from disability discrimination. FMLA is just a whole different animal, and it's a leave statute. And you need to be eligible for coverage, you have to have worked at the job for 1 year. After you hit that 1 year time period, then you're eligible. Any week where you're on the payroll counts as a week of service. So that's the service requirement. So 12 months is the rule of thumb. Then there's the hours requirement. So you must have worked for the company for at least 1,250 hours in that year. So 12 months of service and 1,250 hours in that 12 months. So if you're a part-time employee, you might not meet that threshold. But if you're full-time and you've worked there for 12 months, you'll be covered. And then the worksite requirement. And this goes back to the asterisks that we had earlier. So you have to work at or within 75 miles of a worksite with 50 or more employees. And I'm going to break that down because it's kind of confusing. So let's say a good example is, let's say you work for UPMC. UPMC has thousands and thousands of employees. But if you work for a remote UPMC office where there's only 5 employees and there's no UPMC facility within 75 miles of that worksite, you may not be covered by the FMLA. So wherever your office is, you have to have 50 or more employees in your office or within a 75-mile radius of your office. So if you work at a satellite office of your company, but within 75 miles, there's the corporate office with, 1,000 employees in it, you'd be covered by the FMLA. So it doesn't matter how big your employer is, it matters how big your work site is. So it's a little confusing, but that's really the measure for whether you're covered by the leave statute or not. And so if you are covered, what do you get? You get 12 weeks of job protected unpaid leave per 12 months. If you're in the military, you can get 26 weeks of job protected leave, and that involves military caregiver leave if someone is deployed overseas. FMLA can be taken consecutively or intermittently. We talked about that a little bit already. So some people just have bad days, a couple bad days a month or a week. And so a lot of times what they'll do is have their doctor fill out the paperwork and say, I anticipate this employee will have 3 bad days a month. And so you would just call in the morning of, or whenever you're capable of calling in and saying, I'm taking a day this week. And that's how a lot of people use it, because they have good days and bad days. Or you can use it for a half a day, or you can use it to go to a doctor's appointment or something like that, or tests or surgery. Or for treatments. Those are all options that are available to you. Giulia, do you want to talk about the reasons for FMLA?
Sure. So an employee is entitled to 12 weeks of leave for a number of reasons. It could be because of their own serious health condition, and I'll talk about what that encompasses in a little bit here. When the employee is needed to care for a family member's serious health condition, to care for a child after birth, placement for adoption, or foster care with an employee, or to address a qualifying exigency, related to the deployment of an employee's family member. And then if we go to the next slide, I'll tell you exactly what a serious health condition is. A serious health condition is an illness, an injury, an impairment, or a physical or mental condition that might involve inpatient care or some sort of incapacity for more than 3 days, plus some continuing treatment. And some examples of that would be due to pregnancy or prenatal care, a chronic health condition, permanent or long-term conditions, or multiple treatments. So this is different from a disability in that it's the definition is broader. And when I say disability, I mean the definition of disability under the ADA. It encompasses illnesses, injuries, impairments, or other physical or mental conditions that would require multiple treatments and maybe some intermittent absences. If an injury causes a permanent mental or physical impairment that substantially limits a major life activity, that might also qualify that certain condition as a disability under the ADA.
And Giulia makes an important point because those two are, to be covered by these laws, you have to meet the definitions. But Parkinson's would meet the definition under any of these laws. So it would be a serious health condition, and it is a disability under the Americans with Disabilities Act, without question. So as long as you meet the other requirements for FMLA coverage, then you would be covered by that law. And you're automatically covered by the Americans with Disabilities Act because it is, just by its nature, considered a disability under the law.
So job restoration, let's say you take your FMLA leave and you're getting ready to come back. Your employer is required to provide you with either the same or an equivalent position with equal pay, benefits, and other terms and conditions of your employment that you had before your leave. You're entitled to reinstatement even if the company has hired a temp in your absence or otherwise restructured your position while you were on leave. I'll make a note here that an employer may ask for some sort of physical or a fitness for duty certification before you do return, if they have a reasonable belief that your ability to perform your job functions might be impacted by your condition for which you took leave. Particularly, this is important when there are safety concerns associated with the condition. Okay. Coordination with other kinds of leave, such as sick leave or vacation. During periods of FMLA leave, the employer or employees might be required to use another form of paid leave. So that could be your accrued sick leave or accrued vacation time. And the use of such leave would run concurrently with your FMLA leave. The employer can do this. They have the right to do this if the reason for your FMLA leave is covered by their own policies, such as their policy for sick leave or other kinds of leave.
And this can be very frustrating to people that we counsel because you're out on leave and you get back from a medical leave and you've got no vacation left because you had to use it at the same time. But that is the nature of the law, and that is something most employers do, is they make you burn your vacation at the same time you're on FMLA, which can be very frustrating.
Certainly frustrating. Interference and retaliation. So FMLA interference would look like a situation like this where an employee is entitled to go on FMLA leave. The employer either denies it or strongly discourages it. That's it. That's all you need to show to get interference. There's no intent required. You don't have to show that there was intent to be malicious or to discriminate against that particular reason for the leave. Retaliation is a little bit different. That would be an adverse action because the employee requested to go on FMLA leave. So that might look like a demotion at work, termination, harassment, something like that. And for that, intent is required. You need to show some sort of discriminatory intent to make a retaliation case.
And the most common situation we see with any type of discrimination or retaliation is the employer finds out about the employee's disability, or the employee requests an accommodation, or the employee takes leave, and suddenly their performance tanks in the employer's eyes, and the employer usually makes up some reason to justify their exit. So that's something that we get calls on all the time, where someone, shortly after coming back from a leave, suddenly finds out that they were the worst employee ever. And that's timing is a real clear sign of retaliation in our world. Employers don't typically come right out and say they're discriminating against you or make disparaging remarks, although sometimes they can. We'll see cases where an employer will ask maybe subtle things about the employee and, pretend like they really care about their medical condition, but then end up using it against them. So you'll see those remarks as well sometimes.
Just to be clear in one thing, FMLA is unpaid leave, whereas vacation will be paid, right?
Correct. So while you're on FMLA, let's say you have 2 weeks of vacation and 12 weeks of FMLA. The first 2 weeks of your FMLA would be paid because they'd be making you use your vacation at the same time.
I see.
And then the rest would be unpaid, and then unfortunately you'll get back with no vacation. The only other way you might get paid on FMLA is if your employer has a short-term or long-term disability policy. And that's not a state law or federal law. It's just an insurance plan basically that your employer offers, or some employers offer it. And if you're on FMLA, you could qualify for short-term disability under that, or long-term disability. These are all the bare minimums that employers have to provide. And I don't mean to sound cynical, because some employers do bend over backwards and really help people who are struggling with their health. But, I guess because I see the worst of it, then I tend to be, I guess, a little pessimistic in employers and maintaining individuals and protecting their rights. But what I would say is, we want to talk about the bare minimum, but if your employer can always give you more leave. They can always give you more than the 12 weeks if they so desire. So that's the minimum, but they can give you more. And some employers do. Some employers will keep your job open for a long period of time. But if you are FMLA eligible, they have to at least give you the 12 weeks.
All right, I'll kind of do a wrap up here and explain what kind of, which laws apply to which employers. So the ADA applies to employers that have 15 or more employees. The PHRA, that's the Pennsylvania state law, applies to an employer that has 4 or more employees. And the FMLA applies to employers that have 50 or more employees within that 75-mile radius that we discussed earlier. Workers' comp applies to nearly all employers, so that's good to know moving forward. And what laws would apply to an individual employee situation? So the ADA would apply to situations in which the employee has a disability. The FMLA would apply to serious health conditions, and workers' comp applies exclusively to work-related injuries. I think that's what we got for you guys. Any questions?
Any questions? Yeah, happy to answer any questions that people may have. I can stop sharing.
I don't have any actual questions, but I appreciate very much the presentation. I'm probably going to urge our children to go ahead and look at it and see how the various laws may apply to them. I'm not ready to discuss situations that happened years ago and in Ohio with previous employer and so forth. There wasn't anything legal, but there were some interesting situations that I don't want to have recorded, but I appreciate very much your input.
Yeah, absolutely. We're happy to be here, and we appreciate the time to speak to your membership. I know these are questions I'm sure that Casey, that you come across sometimes, and unfortunately people kind of struggle through.
Right, and understandably so. It's very helpful.
Yes, thank you very much for the knowledge and the time. I appreciate it very much.
Yeah, we really appreciate it. Any other questions before Giulia and Nick sign off?
No, thank you very much.
You're welcome. Oh, go ahead. Oh, I thought someone said something. Yes, thank you so much. We really appreciate your time, and if anyone would like Julia and or Nick's contact information, you're welcome to email me, cpeluso@pfwpa.org. All right, bye everybody. Thanks again.
Sure.
Bye-bye.
See you guys.
Thank you.
Bye.